Welcome to The Explainer. So today we're diving into what is essentially a massive, high-stakes game of chess. On one side of the board, you have the global pharmaceutical industry using really sophisticated lifecycle strategies to protect their multi-billion-dollar R&D investments. And on the flip side, national public health frameworks, which are specifically designed to make sure local populations can actually get their hands on affordable medications. We're going to break down one of the absolute most defining legal battles in modern medical history. It's a clash that literally changed the entire playbook for how pharmaceutical giants approach global markets. Okay, let's dive into this. The entire strategic conflict we're analyzing today hinges on this single fundamental question. What exactly happens when a billion-dollar corporate strategy slams right into a legal wall built specifically to stop it? To really grasp the magnitude of this collision, we first need to understand the pharmaceutical industry's opening move. So, that opening move is a strategy known as evergreening. It's an incredibly common corporate strategy used to extend a patent's life cycle. Think about it. Developing a totally new drug costs billions of dollars. So, to maximize the return on that massive initial investment, companies will make minor, incremental changes to the original drug. This might mean tweaking its crystal structure, which is called a polymorph, or altering its chemical salts and isomers. And these minor modifications, they allow companies to apply for secondary patents, which effectively keeps generic competitors off the market for years, sometimes decades longer. It is a highly lucrative strategy, and it's perfectly legal in many jurisdictions. But strategies that work in one territory definitely don't always work in another. Let's walk through the timeline for our main player here, Novartis. Way back in 92 and 93, scientists at what is now Novartis synthesized this incredible origin molecule called imatinib, and they patented it globally. India, however, was deliberately excluded from this. At the time, Indian local laws only allowed patents for manufacturing processes, not the final products themselves, which was actually a deliberate strategy to build up their own domestic manufacturing capacity. Fast forward a bit to 1997. Novartis executes a classic life cycle management move. They file a secondary patent in Switzerland for the beta-crystalline form of imatinib. This specific tweaked form is what would eventually become the absolute blockbuster cancer drug, Glivec. Now, because India had joined the WTO by this point and was in a 10-year transition period to start accepting product patents, Novartis just dropped this new application into India's legal mailbox in 1998. By 2001, the US FDA approves Glivec, and they were literally calling it a magic bullet for leukemia. Now, when Novartis officially launched Glivec and secured their exclusive marketing rights, this was the price tag they set: $2,666 per patient per month. It was a very standard high-margin strategy for Western markets, but in India, that translated to roughly 1,20,000 rupees every single month for a life-saving cancer treatment. But contrast that immediately with the second number, $177. Because Indian generic manufacturers were already producing the drug before the new global trade laws took full effect, they were out there selling the exact same treatment for just a fraction of the cost. The strategic stakes here were absolutely massive. You had Novartis needing to protect a billion-dollar corporate asset, while Indian generic companies were entirely focused on producing high-volume, affordable medicine. Which brings us to Section 2, the countermove. Enter Section 3D. Now, what's really interesting about this slide is how India created a calculated legal defense mechanism. In 2005, India's WTO transition period ended, meaning they had to fully amend their Patents Act to comply with global trade rules. Basically, they had to start granting product patents. But to shield their massive domestic generic industry, they crafted this highly surgical legal block, Section 3D. This provision explicitly stated that simply discovering a new form of a known substance does not qualify for a patent, unless it shows a significant enhancement in known efficacy. It was a brilliantly designed, strict legal wall built to stop blind evergreening in its tracks. So here we see an absolute mismatch in strategies. They are speaking two different languages. Novartis approached the Indian Patent Office relying purely on physicochemical improvements. They were arguing things like, well, their new beta-crystalline form had better manufacturing flow, thermodynamic stability, and absorbed less moisture. And to be fair, those arguments often successfully secure secondary patents in Western offices. But under Section 3D, the Indian legal framework demanded proven therapeutic efficacy. They needed cold, hard proof that the drug actually treated the patient's cancer significantly better than the original 1993 molecule. And Novartis just didn't provide the data to prove that it did. This totally incompatible strategic mismatch sparked a massive, escalating legal war. Step 1. In 2006, the assistant controller of patents in Chennai flat out rejects the application under Section 3D. Step 2. Novartis goes on the offensive. They try to argue that Section 3D is actually unconstitutional. They lose at the High Court, they appeal to the Appellate Board. Actually, they even bring in new data at this point, claiming a 30% increase in bioavailability in rats. But they get rejected again, which forces Step 3. The ultimate, high-stakes, final showdown at the Supreme Court of India in 2013. And here is the checkmate. April 2013, the Supreme Court of India officially dismisses Novartis' appeal. They set a completely firm precedent. Under Section 3D, efficacy strictly literally means therapeutic efficacy. Simply proving better bioavailability, meaning more of the drug physically enters a rat's bloodstream, that was not enough. Because Novartis couldn't prove the new form was therapeutically superior for the actual human patient, the Evergreening attempt was killed. The patent was officially denied. Now, you might be wondering, why did India fight this defensive battle so fiercely? Well, it wasn't just about cancer drugs, not by a long shot. It was about protecting their critical role as the pharmacy of the developing world. To put this into perspective, Indian domestic generics account for 90% of product sales within India itself, and they supply a staggering 80% of all HIV drugs to the entire developing world. That's millions of lives. If Section 3D had fallen to Novartis' strategy, the global supply chain for affordable medicine would have been completely reshaped overnight. And this brings us right to Section 3, the pivot, how Gilead changes the game. And this brilliantly illustrates a completely new strategic meta. The entire pharmaceutical industry had just watched Novartis spend years in incredibly costly litigation, only to walk away with absolutely nothing. Another giant, Gilead, watched this happen and realized that trying to force that old monopoly strategy through the Indian legal system was commercially irrational. They needed a completely new approach. The old way meant pushing for a monopoly, keeping prices high, and ultimately just losing the market when the patent failed. Gilead's new way? Voluntary licensing. Instead of spending millions fighting the generic network in court, they decided to monetize it. They partnered with them. Let's walk through exactly how this worked. Rather than waiting years for courts to decide their fate, Gilead proactively issued voluntary licenses to generic manufacturers. For major breakthrough drugs like Sovaldi and Remdesivir, Gilead partnered directly with huge Indian generic companies like Cipla and Hetero. This strategy was an absolute masterclass in economic compromise. Gilead got to maintain their highly profitable monopolies in the US and EU markets, while the Indian generics rapidly manufactured and supplied 101 developing countries at a very low cost. By taking just a 5 to 7% royalty on those sales, Gilead secured pure profit from those developing regions without spending a single dime on local manufacturing or distribution. When you can't enforce a monopoly, strategic cooperation creates a massive win-win. We're going to wrap up this explainer with this incredibly powerful quote that perfectly summarizes this new strategic reality. In India, patentability is not just about novelty, it is about proven therapeutic advantage. The Novartis case proved for sure that the exact same molecule will face entirely different economic battlefields depending entirely on local laws. It cemented Section 3D as this formidable new model, forcing massive companies to adapt their global strategies rather than just blindly relying on litigation. But it leaves us with a really fascinating question. As the next huge wave of biotech and AI-driven medical breakthroughs emerge, how will these corporate profit strategies adapt when they inevitably collide with the immovable object of public health frameworks next? Think about it. Thanks so much for joining me for this explainer, and keep questioning the strategy behind the science.